this public meeting on January 12th, 2026 at 5 p.m. And welcome those that are attending virtually, of course, and welcome those that are in the gallery with us this evening. And we're always glad to have our staff with us to give us that facts information that will provide us the best information to make the best decisions on behalf of the residents of South Huron. We'll now call this meeting to order and we'll ask for roll call. So if you could unmute your mics, please, and I'll call your names. Councillor Oak.
Here.
Councillor Neeb.
Here.
Councillor Dietrich. Councillor Vaughn.
Here.
Councillor McLeod-Haggett.
Here.
And Deputy Mayor.
Here.
Thank you. And I'll turn this meeting, sorry, is there a disclosure of pecuniary interest at this time by any members of council? Not seeing, we'll turn the meeting over to our staff. Alex, whenever you're ready.
The purpose of this public meeting of the Council of the Corporation of the Municipality of South Huron is to consider and review a proposed zoning bylaw amendment under Section 34 of the Planning Act. This meeting is also to allow interested members of the public the opportunity to ask questions or offer comments on the application. Council will not make a decision on the proposed amendments at this public meeting, but based on the recommendations and information received at this meeting, the proposed amendments will be presented for approval at a regular council meeting. The public registry for the application is located by the door over on the table there. And any member of the public who would like to be notified in writing of the decision are to provide their name and mailing address on the list or contact myself, the clerk, to be added. Members of the public do not have the right to appeal the decision. Only the applicant, the property owner, the Ministry of Municipal Affairs and Housing, a specified person under the Planning Act, or public body that has an interest in the matter may appeal the decision. Please refer to the County of Huron website for details on appeal rights.
Thank you, Madam Clerk. And we turn to our friend, our planner, Victor Clues, whenever you're ready, please.
Thank you, Your Worship, members of council. Yes, this is file Z03-2025, which is at 12 Victoria Ave West in Crediton, and it's a zoning bylaw amendment application. It's on, I'll call it the west side of Crediton, and I have to apologize, our key maps for Crediton, because of the shape of the settlement area, they rotate. So north is on the left-hand side if you're looking at that zoning map. I know that always confuses me. Essentially, what is being proposed is a zone change from R2 residential medium density to R3-19, which is a high density residential special zone. And staff are also recommending a holding provision be included. That holding provision would be over, I'll call it the back third of the property. And I'll get to the specific reasons for the holding in my report. The application is needed because while the existing zoning would allow for 6 residential units on the property as a multiple unit residential dwelling, the applicants want to build their new units, their 3 new units, as a separate row house style structure in the rear yard. So they are asking for rear yard setback relief. But they are also applying for the high density residential zone because it allows for multiple buildings as of right. The specific zone provisions, there are 3 that are essentially recognizing the existing triplex at the front of the property. So that's a reduction to the frontage from 19 meters to 17.2 meters. The front yard setback being reduced down to 2.4 meters from 6 meters, and the interior side yard setbacks, 1.4 meters on the west side and 2.7 meters on the east side. And I'll note on the west side, there is an existing easement that is on the neighboring property, and that's part of why that setback is so small on that west side. That laneway is on the neighbor's property with an easement to allow transportation over it. The new relief would be a reduced outdoor amenity area, slight reduction from 100 square meters to 90 square meters for the multiple unit residential zone provisions, and a reduced rear yard setback of 5.9 meters where 10 meters would be required. The bylaw provisions range for rear yard setbacks. Typically they go between 7 meters and 10 meters. So this is a little lower than the lowest end. And it's because of the interior configuration. This is the existing condition of the site. You can see the existing triplex at the front of the property, an existing garage that's being proposed to be taken down. The new 3-unit row house style structure would be at the rear of the property. This is the front of the property. So this is that existing access easement that I was describing and the existing 3-unit building. This gives council an idea of what the applicants are proposing here. So you can see at the south side of the property, there's the existing 2-story triplex. Then there's a parking area that would provide parking for both the existing and the new building. One accessible parking space at the north end, and then they are meeting their parking requirements. And then there would be a 3-unit, 2-story row house. It's shown as a triplex on the drawings, but because all of the units would be vertically divided from each other, it actually meets the row house definition. You can see the proposal on the right-hand side, relatively basic floor plan with some windows and 3 separate access doors. There are outstanding concerns with the application from South Huron staff, specifically the servicing. There had been some back and forth on the file, and then the applicants weren't responding for a while on a specific servicing concern about the minimum spatial separation between a water line and a stormwater line. Staff are satisfied that it is possible to service the property, but before the building is allowed to be built, those details do need to be resolved. And so the recommendation is to approve the rezoning subject to a holding provision that would only be lifted when those servicing provisions are provided. And at the time of preparing my report, we hadn't received any public comments. We have received a letter of objection since from a neighbor, and I understand that another neighbor may be coming to the meeting to speak. Both residents of Crediton. At a high level, and my report goes through this in more detail, infill and intensification are supported and encouraged by the provincial planning statement, the Huron County official plan, and the South Huron official plan. This is a fully serviced site, and we would support a range of housing types and increasing the density on the property. There are a number of specific criteria in the South Huron official plan. I think that font size is a little too small for you, but the most important one is bolded and it's outlined in the report. And it's the requirement that full municipal services need to be connected and that the application needs to demonstrate the ability to manage stormwater, lock rating, and drainage. At a high level, they've gotten most of the way there, I'd say. So we are in a position where we can support the proposal, but we do need that holding provision to make sure that the legal required setbacks between the water line and the stormwater line are being met. Since the proposed holding provision, which is clause C in the draft bylaw, is a change to the bylaw from what was applied for and what was circulated in advance of the public meeting. If council chooses to make that change, it is recommended that you consider making a motion under 3417 of the Planning Act, which is essentially that no further notice is required as a result of the change. In my mind, that is appropriate because the change is minor. It doesn't change the result of the proposal. It just puts out a requirement in place before the development can proceed. And in summary, the application complies with the Planning Act, is consistent with the provincial planning statement, and conforms to both the county and the South Huron official plan, and I am recommending approval, and I'm happy to take any questions.
Thank you very much, Victor. Any questions from members of council? Councillor Vaughn, please.
Thanks for the report, Victor. You were talking a bit about the driveway on the west side of the property. Were you saying something about that's a right of way that's been given to the owner of the?
Yes, if I may, through the chair, I will just pull back up my slides quickly. I jumped the gun on closing that.
Sure.
So this is an existing easement that's registered, and in the air photo that's up on the screen, you can just see the lines. So there's a easement registered over this portion of the neighboring property. that allows for the full width of that driveway. Otherwise, only a portion of the driveway is on the subject lands. And so that easement continues to be in effect. We have had correspondence with the applicants, and they've confirmed with their lawyer that they can modify that driveway and continue to use it.
Okay, and so also in that general area, on the property just west is a tree right near the sidewalk and near that driveway where the easement is. So what's happening with that tree? Because it's kind of it's a narrow laneway for starters, and the tree is the boughs on the tree are quite low. Doesn't look like you could get even a high truck for a moving van through that laneway, and I don't see an entrance anywhere else. So from a moving perspective and also from a emergency perspective, if there's higher trucks, what's going to happen with that tree, if anything?
And through the mayor, I'm not sure. The applicant's planner is on the meeting tonight, and so you might be able to ask them for more details. It might be that they've already planned on removing some limbs from the tree for construction access to the rear yard. It's not shown as being removed or anything like that, but I'm frankly not sure what the long-term plan is for the tree.
And while we're on that topic, is the planner available to provide that information now?
Good evening, Council. It's Matt Campbell here from Zelenka Preamo. Can you hear me okay?
Yes, we can. Did you hear the question about the tree?
I did, Mayor Finch, and through you, I'd like to be able to just provide a brief comment on that. We haven't had any specific commentary or direction from our client in regards to that tree, but what I can say is that if that tree is posing a conflict with whether it's construction traffic, ongoing resident traffic, we would defer to civil law regarding what would happen with that tree. That tree is on the neighbor's property, so that tree is protected by common law. We can't just go and remove that tree, and that would likely be negotiated with the neighbor if anything were to propose to be happening with it. But I can advise at this point, I haven't had specific discussions with our client regarding that tree. That would likely come out more meaningful once the development is looking at going through the building permit process.
Thank you. Councillor Vaughn, you had something else?
Yes, just sort of furthering on that whole thinking, from emergency vehicle access, like fire and ambulance and so forth, if there was a need to get to a new building that would be in the back of that property, I would think that tree would cause a bit of a challenge. So I'm just wondering if that's also a part of the site building planning before we actually start building.
Any comments, Matt, or from Victor?
Through you, Mr. Mayor, the only comment I can really provide there is that it would be up to the municipality's building department to determine whether any specific fire lane would be required there. Today, there hasn't been a discussion about a fire lane, and there hasn't been a meaningful discussion about any access concerns to this property. I can advise that the owner, Mr. Helder, owns the next property to the north as well. And that might be useful for an access there, but that hasn't been really raised as a topic of conversation to this point, to my knowledge.
Okay, thank you. Members of staff, anyone wish to comment? Mr. Roll, go ahead, please.
Sure, thank you. Through the mayor. It's an excellent question. As these buildings are considered small buildings within the Ontario Building Code, there is not a requirement for a fire lane per se. If it was a bigger development, larger building, more stories, you would be required to have a lane that's not less than 3 meters wide that you could fit a fire truck through, EMS through. But in this particular case, the Ontario Building Code would not require that. However, as it's brought up, we will bring this forward to the owner and have them address that during the application process. But it's not something I'll be able to hold back the issuance of that building permit for. We'll just make them aware of it and note it.
Thank you. Any other questions? Councillor Oak?
Thank you, Mayor. Just a question. What, with the new row housing, what lot coverage are we looking at, Victor, as far as total lot?
Perfect. And through the chair, the total lot coverage at the end of the day would be 29%, where the maximum is 40%. So it's quite a bit under the maximum.
Okay, thank you. Any other questions? Deputy, go ahead, please.
Thank you. Just a question. We go back to where that tree was. That driveway, that concrete driveway between the tree and the building, is that the entrance way back in there? Like it doesn't, to me, it doesn't look very wide, but it's hard to see in the picture here.
Yes, the plans show that they'd have a 3.2 meter wide driveway, which is a little wider than a standard like single way in, single way out driveway. And essentially it would be remaining as the driveway there. They're not proposing, a major widening or a new driveway.
Councillor Oak.
Yeah, thank you, Mayor. The other question I had was there's 6 parking spots. One is accessible. What happens if there's 6 vehicles and none of them are accessible? How do we work the parking on that? We wouldn't have one per unit then.
I can speak to it at a very high level. So we don't tend to get involved as the municipality or as the planners in the management of these properties. I believe that they are planning for a degree of accessibility in at least one of the units. I'm remembering back to some materials they had provided with their application, but it is a good point, and that could be a challenge for them. I don't know if their planner has any insight from their conversations with the owner.
Matt, do you have any comments on that?
Through you, Mr. Mayor, I don't have any specific comments, but only a rather general comments where, when individuals are going to be leasing, or if this ends up becoming condominium, buying a unit, the parking expectations and parking supply are made very aware to potential purchasers or leasers, so that everyone is very, very well informed as to what the parking supply and parking arrangements are. It's not like anything would be a surprise here. But if could I get the councilor to repeat the question? I'm not sure I understood it properly. Maybe I can paraphrase. If there is if parking is full and someone requires accessible parking, what do we do then? Was that the question?
Thank you. My question is, right now there's 5 proposed regular parking spaces and 1 accessible only parking space. I assume that means one of the units would have to be accessible, or that's all that could park in that space is an accessible, because you can't park in unless you have the designated accessible sticker. You can't park in an accessible parking space. So just wondering if there wasn't somebody needing an accessible space, can they use that space as a regular space?
Matt?
I think that's a great question. I'm not able to answer that absolutely, but what I can say is that in similar situations when our clients have been required to have an accessible space for a triplex or 5-plex, that kind of thing, and none of the residents have actually required it, but they wanted to make full use of the parking, they've simply just parked there. And then if someone needed to use that space for accessibility purposes, well, then the owner made it abundantly clear to everyone that space would be for that tenant.
Thank you. Any other questions? Okay, I'm not seeing you. Oh, Councillor Oak, go ahead.
Thank you. The planner for the applicant made a comment about the possibility that these are going to be sold. Can you enlighten us further on that?
Go ahead, Matt.
Thanks, and through you, Mr. Mayor. There was a general comment just to say that a lot of our clients have the opportunity whether or not they want to place a planned condominium on any residential or actually any property for that matter. And in a lot of cases, our clients will use those for tax and estate planning purposes, not necessarily that they would sell those units off to, call it the general population or put them on the market, so to speak. So I just raise it because the landowner would have that opportunity under the Planning Act at a later date, should they so choose to do that. That hasn't been, again, a meaningful topic of conversation. I have nothing to suggest that we're going to do that imminently, but that it could be a possibility in the future. It wouldn't change anything about the development itself. It would just change the fact that someone could buy a unit in a condominium in one of these buildings.
Okay, thank you. Any other questions? Okay, we'll go to the public. Madam Clerk.
David Matter.
Welcome, David. Just come to the first chair there and turn the microphone on and begin whenever you're ready.
Good evening, everyone. Thank you for having me here. My name is David Mader, and I live at 8 Victoria Ave West in Crediton. We have lived there for approximately 5 years. I live with my wife, Nicole, and 3 small children, aged 6 months, 4 years, and 6 years. We are the house immediately east of this proposed development. I work nearby at the Centralia Airport, and my wife is a financial advisor at the local healthcare worker. This is our first home, and we are learning a lot about home ownership, especially in water and drainage, which we have learned is a common problem and a popular topic in the village of Crediton. Page 13 shows a detailed sketch in what we can see that the existing sidewalk on the east side abuts my property very close. At this point, I have a question for clarification, as the drawing indicates a 2.7 meter setback on the east side, which is the side my house sits on. But further on the application, the pages 27, 28, and maybe other places, the proposal references an east side setback of 1.7. I'm wondering if the consultant has mixed up east and west here, or regardless, my house sits on the east side, and assuming the setback is 2.7, the drawing is correct and proposed setback of the new building will be 3 meters as indicated on page 28. Page 14 talks about surface water in the parking area to be expanded. Hardened surfaces promote runoff, and we have significant water problems on our property, as do many residents in Crediton. We are concerned that the increased paved area will increase runoff onto our adjacent land, including our house. Right now, the water runoff from the paved area runs directly into our house, which is causing significant problems for us. Page 14 also talks about appropriate side yard setbacks and refers to landscaping buffers and fencing along these setbacks. Page 18, section 6.0 on stormwater management suggests that much of this site's runoff will be through grassed swales. My question is where? With a 3 meter setback with just less than 10 feet, how can a grass swale, landscaping, fencing be accommodated to along the patio spaces outside of the patio doors with dividing fences that are showing in the drawing for the east side of the building, the side that our fence will be backed onto? Where will the eaves troughs drain in, and how will this water be safely and fairly accommodated in such a small area so that it does not drain into mine or neighbors' backyards? In the same paragraph, we read that during construction site, disturbance will likely be caused by soil erosion and silt runoff, and that temporary silt control measures are recommended, and that a ponding area to be constructed. Given the proximity of my yard to the proposed construction, I'm interested in knowing where the ponding area will be located and how erosion control can be effectively implemented in a 10-foot setback. I have taken all the measures as a homeowner can take at my own cost to mitigate the risk of flooding on my own property, including tile draining around the house and the installation of a sump pump. During heavy rains, my sump pump runs every 35 to 40 seconds. I'm understandably concerned about the conditions that this may increase the amount of water on my property and that they have to deal with. Concern 2, privacy and buffers. As mentioned, I have 3 small children, a baby girl, and 2 little boys. The existing apartment complex overlooks the roof of our house, and this affords us some privacy in our backyard, which we have enjoyed to date. The proposal refers to landscape buffers and fencing for the new building, but it is unclear what this will look like or to the extent it will afford some privacy to adjacent neighbors. To summarize my questions and concerns, I'm concerned about the effective mitigation of runoff during construction, including the grass swales and ponding area, and post-build. I would appreciate greater detail on the landscape buffers and fencing on the east side. In a small community, it is important to be a good neighbor, and we have been nothing short of that. As I speak for my family here today, we are greatly concerned about how this proposal moves forward. We are a young family trying to make credit in our home. We work locally and are part of this community. It is important that developers not only consider the neighbors when proposing a build, but also their surroundings, the impact on the developing proposed areas, and most importantly, the effect on the community as a whole. Thank you.
Well done. Victor, would you be able to address these concerns?
Yes, thank you. I can speak to some of the concerns and or some of the clarification that you were asking for, I think mostly. So there are some typographic errors in the application materials. I had only caught them when I was preparing my report for council because I had brought some of the wests and easts in and it barely didn't come into the report in front of you tonight. So the setback is 2.7 meters in their plan and in their proposal from the existing building to the east lot line. And the new setback would be 3 meters. So you were correct in catching the error in some of the documentation there. As far as the servicing proposal, as I outlined in my report to council, we are still working on the details of the servicing and specifically the stormwater management, exactly where that stormwater pipe would go, because right now it's too close to the proposed water line. But at a high level, the applicants are proposing swales to the west and to the east of the new two-story triplex, or a two-story row house. Those would go to catch basins. And so it wouldn't be overland flow over the whole property. It would be overland flow in the swale until it gets to a catch basin. Those catch basins would then gather in the parking area under the new asphalt parking area and then come out to the road through a pipe. So there would be a total of 4 catch basins on the property. But again, the exact detail of where the pipe will be is part of why we want that holding provision put on the proposal.
Thank you. Any other comments about that? Okay. All right. Any other comments from anyone else? Sorry. Milt, did you have a comment? Go ahead, Councillor Dietrich.
Thanks to the mayor. Michael, this one's for you. Will you be asking for a lot grading plan?
To the mayor. Yes, most certainly. It'll be a lot grading and drainage plan.
Thank you. Any other questions at this time from members of council before we go back to the public? You're not seeing, Madam Clerk, whenever you're ready. Anyone else?
It appears we have a Brian Linker online. I'm not sure if he'd like to speak.
Mr. Linker, can you hear me? Mr. Linker? Mr. Linker, are you there?
Can you hear me?
I can. Go ahead.
What would you like to know?
You have some comments?
No, I'm Dennis's father-in-law, also a developer. Just listening in to see if there's any concerns that I can help.
Okay. If you have nothing else, if anyone have any questions of Mr. Linker? Not seeing any at this time. Okay, thank you for your participation. Madam Clerk?
We also have the property owner, Dennis, online. I'm not sure if he'd like to speak.
Dennis, are you there?
Yeah, I'm here.
Go ahead whenever you're ready.
Yeah, no comments at this time. I think it's fairly thorough as it was, so I'm just going to hold comments for now.
Okay, does anyone, a member of council, have a question for Mr.? No? Okay, thank you. Okay, Madam Clerk, anything else?
So there are no other individuals online. I'm not sure if anybody else in the gallery would like to speak.
Not seeing any. Okay, thank you. Anything further? Sorry. Okay, Matt, would you like to say anything else, Mr. Campbell? Any other comments?
Thank you, Mr. Mayor. I don't have any additional comments that haven't really been addressed, other than just a note on the holding provision. While in principle, we have no objections to it, in principle, yeah, it makes a lot of sense to figure out how the servicing is going to work in a very detailed way before we issue building permits here. I just request some consideration in that, and perhaps Mr. Rolfe could comment on this as well. It's my view and my understanding that there are sufficient protections under the Ontario Building Code that would give municipal staff the tools and the level of certainty to withhold a building permit issuance until those servicing issues have been worked out to their satisfaction. My only concern is that the addition of a holding provision simply adds another administrative process into the development of the site, which I think in principle, yes, it makes sense to figure that out. I'm just wondering if it may not be necessary, given the other tools that we have under the OBC to deal with that particular issue. We may be able to achieve the same outcome with a little bit less work on both sides of the table here. I'm just asking for some commentary on that.
Mr. Rolfe, comment?
So the mayor. Yeah, you're not wrong, Matt. The OBC does require or have certain provisions for spatial separations from your water mains and your storms and sanitary and such. But that wasn't the only concern that municipality had. We also had concerns regarding the metering, right? How that's going to work, where that water service is going to come into that property, whether it's going to be metered from 1 meter and then service the rest of the buildings, or whether each of those new suites or dwellings are going to be metered. So that has not been resolved yet, and that would not be within the OBC. So we will need to have that holding symbol on.
Okay, any response, Mr. Campbell? Matt?
I don't think so. I think that answers my question. I appreciate the response.
Okay, thank you. Councillor McLeod-Haggett, please.
Thank you, through Mr. This might be for you, Mike. Going forward, then, giving the adjacent properties concerns with the water, and I'm familiar with the water issues that they have in Crediton. Would you be communicating with that homeowner as well going forward if this is passed, to make sure that he's got some reassurance that those water issues are not going to overflow onto his property, which then causes him and his family further stress on the situation that is kind of already there?
So the mayor, so the design that we will have received and will receive more as the design gets flushed out with orientation of the stormwater system and such. The intention is to maintain all that water within that existing property. So shed no water beyond. Everything is within eaves troughs. Any kind of impermeable surfaces are, discharged into those catch basins or manholes. Typically, we do not reach out to the neighboring property owner and say, "Hey, this is what's going to happen and how the design is." However, I have no problem having that conversation and just saying, "Hey, this is how it's designed. You're going to have a swale that's 1.5 meters off your property line, so deep to the west," and kind of describing it that way. So yes, we can stay in communication with the neighbor, but the design itself and how it's accepted would be through the municipality and potentially our third-party engineers.
Councillor Roque.
Yeah, thank you, Mayor. And further to that, it'll be coming back to a regular council meeting with those details in it as well, right? Is that the plan?
To the mayor. So no. So this is not for site plan control.
Okay.
This is for zoning bylaw amendment only. So we're basically just looking at rezoning for the higher density and the setbacks. So not a site plan control. So that kind of detail will not be coming back.
Victor, do you want to comment?
I agree with Mike, and I would just clarify also, there would likely be an easement severance application coming back to council at some point in the near future, I hope. And the lifting of the holding would come back.
Council.
Yeah, that's what I was going to ask. The removing of the holding would have to come back to us.
So the mayor, yes, you're correct. And that would just be an application for the removal. Typically, we don't get into full design. It's just saying that staff has been, staff is satisfied. The conditions have been met.
Okay, thank you. Any other questions at all from members of council? Any questions from those in the gallery? Any comments from those online? Okay, not seeing any. Okay, thank you everyone for took the time to participate in the public meeting. We appreciate that, of course, and I think we've learned a lot and good information has been provided. Thank you very much for coming in. Madam Clerk.
The South Huron Council now closes the public meeting at 5:36 p.m.
Moved by Deputy Mayor, second by Councillor Neeb. Any discussion?